A new notice of proposed rulemaking from the Department of Transportation indicates that the Trump administration is putting its philosophy of less regulation and more collaboration with industry into place. Comments are due by June 16th. Here with insights on how the proposed rules might affect the relationship between the regulators and industry is partner at Cozen O'Connor, Michael Deutsch. Mr. Deutsch, thank you so much for joining me today.
Thank you. Happy to be here.
We're going to dig into a notice of proposed rulemaking from the Department of Transportation. But before we do that, you specialize in the regulatory field. What are some of the main differences between the regulatory approaches of the Trump and the Biden administrations?
That's a great question, Terry, and I think a great place to begin. So just a little bit of background for your listeners. So I am a partner at Cozen O'Connor. I do aviation regulatory law, and our clients include U.S. and foreign passenger and cargo airlines, public charter operators, global business jet companies, Part 145 repair stations, and other entities that are regulated by the DOT. So all of my comments today are going to be from that perspective, from the perspective of a regulated entity. And so I would answer that question. I would say that under the Biden administration, many regulated entities in the aviation industry felt that DOT took an overly broad and prescriptive regulatory approach. So, for example, in response to an increase in the number of passenger complaints received by DOT during the pandemic, DOT put forth two prominent consumer protection rulemakings. One was addressing airline ancillary service fees, the other addressing consumer protection refunds. And although these proposed rules were well-intentioned, many regulated entities felt that the proposed rules went too far and would lead to higher ticket prices and more consumer confusion. With respect to enforcement, some regulated parties felt that DOT under the Biden administration went from being proactive with respect to regulatory compliance to overly aggressive. So what I mean by that is in the past, there may have been situations where DOT would issue a warning or simply decline to enforce. But during the Biden years, there were more investigations, more enforcement actions, and larger proposed penalties. Now, in contrast, early indications are the Trump administration will seek to decrease regulatory burdens and will aim to take a more measured approach with respect to enforcement. So, for example, since assuming office, the Trump administration has paused enforcement of a complex DOT rule issued at the end of the Biden administration that had significant new requirements for airlines pertaining to the handling and storage of wheelchairs until August. Now, to be clear, the Trump administration's pause does not rescind the rule, rather recognizes that airlines may face implementation challenges and therefore affords them a safe harbor for a time.
So when you think about this new proposed rulemaking, what do you see that follows that trend? What is remarkable in this new proposal?
So the new proposal puts forth reforms in two key areas: DOT enforcement proceedings and the issuance of DOT rulemakings and agency guidance. With respect to enforcement, the NPRM proposes a number of due process and procedural protections for regulated entities, including investigative due process protections specifically prohibiting DOT investigative personnel from conducting, quote, fishing expeditions and treating enforcement as a, quote, gotcha exercise, requiring DOT to provide fair notice to entities facing enforcement action, including notice regarding the relevant legal authorities allegedly violated, and procedural rights. And it also adopts the Brady Rule, which would require DOT personnel to disclose materially exculpatory evidence in the agency's possession without the need for a specific request. Now, notably, the NPRM also states that DOT may only seek civil penalties when, quote, supported by clear statutory authority, and it provides due process protections for regulated entities when DOT violates those due process protections. Specifically, under the NPRM, regulated entities may petition the DOT General Counsel with potential appeal to the DOT Secretary for a determination on whether DOT investigatory and/or enforcement personnel adhere to the proper procedures. With respect to rulemaking and guidance, the NPRM reaffirms the Trump administration's regulatory philosophy, which is in essence that regulation should be narrowly tailored to address specific market failures or statutory mandates, and it also proposes to require all guidance documents to be subject to legal review, drafted in plain language, and include disclaimers confirming their non-binding status.
Well, as you rattled off those provisions, they sound pretty complicated to my untrained transportation regulation ear. Which industries that DOT regulates, and it's got everything from rail to air to roads, which will be most affected by these proposed rules?
So, again, I'm an aviation lawyer, and I can certainly speak that the aviation industry will be impacted by these proposals. But you're right, Terry. These proposals apply across the board to entities that DOT regulates. So it's not just aviation; it's maritime, rail, transit. Any transportation entity that falls under the DOT umbrella will be affected by this.
And so what are you hearing from those regulated industries? Are they in favor of this rulemaking, or do they have concerns?
So generally, I think industry stakeholders are still digesting the proposals. There's a lot here, and it hasn't received a lot of publicity. But broadly speaking, I think many in the industry support the proposals, and to be candid, some would argue that they're long overdue, particularly the due process protections.
I'm speaking with Michael Deutsch. He's a partner at Cozen O'Connor. Will there be changes in the relationship between DOT and the regulated industries as a result?
I think so, and I think there'll be positive changes. I think from the standpoint of rulemaking and the issuance of guidance, these proposals will lead to greater input from industry. At least that's my hope, and that will in turn lead to more informed and well put together rules that hopefully will not come as a surprise to industry.
So you're expecting that the industry folks will submit some comments about this to modify and reshape the boundaries of it then?
Well, not just this specific rule. What I mean by that is the proposals that are talked about in this NPRM will set forth requirements for DOT to follow when promulgating rulemakings in the future. And I'm hopeful that the new policies that DOT will follow for future rulemakings will lead to greater input from industry.
Are there any downsides to the proposals in this memo?
To be candid, I think these proposals provide more opportunities rather than downsides, particularly for regulated entities. For example, with respect to rulemaking, if these reforms get adopted, it should lead to DOT taking a more informed approach. And as I mentioned, it'd be an opportunity for regulated entities to engage in the dialogue and help shape agency regulations and guidance early. So I don't view them as downsides, I view it as opportunities.
But it does seem like the balance of power or the relationship between DOT and the regulated industries will change somewhat. Are there things that the industries can do now to prepare to be able to better provide that input or to respond to this proposal?
DOT has issued a detailed written proposal here, and parties will have the opportunity to file comments. Comments on this specific NPRM are due June 16th, but the comments in and of themselves will highlight what regulated entities and what DOT views as strengths and weaknesses. DOT itself is obligated by law to publish information about what the rules and procedures will be. So there will be a level of transparency. And so no one should be surprised by what the final rulemaking will look like.
And do you expect any changes in regulatory compliance, any long-term effects there?
I think the proposals could lead to an increase in long-term regulatory requirements, particularly requirements around publishing guidance. So oftentimes today, regulated entities find that guidance requirements can be complex and difficult to understand. And the new policies for promulgating guidance, particularly the requirement for guidance to be written in plain English, will, I think, lead to regulated entities better understanding what the requirements are, which in turn, I think, will lead to an increase in long-term regulatory compliance.
Are there any resources or support systems to help the regulated industries navigate these changes?
Well, as I mentioned, the NPRM in and of itself is publicly available. It's pretty detailed. The comments will shed some light. Comments, again, are June 16th. So I would encourage regulated entities, if they weren't able to file comments by that deadline, to at least review comments that have been filed. And then when DOT does issue the final rule, to carefully review the final rule, not just what the new policies will be, but rather also the preamble of the final rule, because that'll explain DOT's thinking, and they'll respond to the comments as well.
Any suggestions for those folks who are thinking about submitting comments?
Yeah, absolutely. And not just for this NPRM, but in general. So the best comments that I have seen are the ones that provide DOT with objective metrics and data in support of their position. And oftentimes, one pitfall that I see is regulated entities, when putting together comments, sometimes they say what their position is, but they don't necessarily back it up with objective data. And DOT, in reviewing these comments, is looking not just for a regulated entity's position, but rather objective evidence, objective data. So to the extent regulated parties can back their positions up, and again, not just with respect to this NPRM, but all rulemakings, with objective metrics, objective data, that will be the most helpful for DOT.
That's important advice. I've been speaking with Michael Deutsch. He's a partner at Cozen O'Connor. Thank you so much for joining me today.
Thank you so much for having me.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Listen to the Federal Drive on your schedule. Subscribe wherever you get your podcasts.